Hello and welcome to the Law of Bryan Fagan. I'm Bryan Fagan, and today we're diving into a topic that viewers of shows like The Sopranos might find intriguing: conflicting out attorneys. In one episode, a neighbor suggests a clever trick to prevent an opposing party from finding legal representation. Today, we'll explore how this scenario would play out in Texas, the legal implications and steps you can take to prevent from falling victim to such tactics. One question I often get is whether a spouse can use the same divorce lawyer in Texas. While this may seem like a convenient option, it's essential to understand that it's considered unethical and a conflict of interest for an attorney to represent both spouses in a divorce. The Texas disciplinary rules of professional conduct lay out clear guidelines on this matter, and we'll explore them in detail. Let's dive into the rules that govern this situation. Texas Rule 1.06b especially addresses conflict of interest, stating that an attorney should forego dual representation when the representation of one client is directly adverse to another client. This is to ensure that each client's best interests are fully considered and represented. To have clear understanding, we'll break down Rule 1.05, Rule 1.06b, and Rule 1.09. These rules emphasize the importance of confidentiality, avoiding conflicts of interest, and prohibiting representation in situations where there is a direct conflict or potential harm to a former client. Now, let me share a real-life scenario I encountered where it seemed like a spouse was deliberately trying to conflict me out from representing the other spouse. We'll discuss the ethical considerations and how this situation unfolded. In examining the ethics opinions, we find that meeting with one spouse can create conflicts of interest, preventing representation of the other spouse. We'll take a closer look at the Ethics Opinion 294 and 494, which shed light on the ethical considerations surrounding divorce consultations and subsequent representation. If a party seeks to disqualify an opposing counsel due to the conflict of interest, there are specific procedures to follow. Filing a motion to disqualify is the first step, and we'll discuss the burden of proof and the elements that must be demonstrated for a successful disqualification. Sometimes conflicts can be waived, but it's crucial to understand the implications. If a party fails to file a motion to disqualify in a timely manner, they may waive the right to raise the complaint. We'll explore the concept of waiving conflicts, its strategic considerations. Now let's address whether the attempting to conflict out an attorney is a good strategy during the Texas divorce. In my professional opinion, I believe it's not. This approach can often escalate conflicts, prolong divorce proceedings, and increase costs. I'll explain why having a competent divorce lawyer for both spouses generally leads to a more efficient and fair resolution. To prevent falling victim to this tactic, it is advisable to meet with a divorce lawyer at the first sign that a divorce may be on the table. Early consultation can limit the options for the other party and ensure you have legal representation. We'll discuss the importance of proactive legal advice and how it can safeguard your interest. In conclusion, conflicting out attorneys is a complex aspect of divorce law in Texas. If you have found this information valuable, please hit that like button, subscribe on our channel for more legal insights, and feel free to share your thoughts and questions in the comments below. Remember that knowledge is key, especially in navigating the legal landscape. Thank you for joining us today, and until next time, take care. Thanks for tuning in to the end. We understand that divorce can be expensive depending on the situation. That's why we're offering our Do-It-Yourself Texas Divorce e-course. You can get access to this e-course by clicking on the link in the description below. Catch you in the next video.